Statutory, Competition and Appeal Tribunal and others.
Yes. Good morning, my lords. I appear with Professor Bailey for the Appellants, the Competition and Markets Authority, or CMA. Mr. Otti King's counsel appears for the respondent Apple with Mr. Parker. Just to start with housekeeping, I think the members of the court are using a mixture of hard copy and electronic bundles. Is that right?
Well, speaking for myself, I'm using hard copies, but
well,
it's too idle to sort it out on electronic, but we'd be fine.
There were some updates in the last few days, so I'll just check that you have everything. There's the core bundle which runs to 8 tabs. There's a supplementary bundle which runs to 14 tabs, which was updated last week. And there's an authorities bundle which now also runs to 14 tabs, which is split across 2 volumes. So I'm grateful. The plan is for me to make my submissions this morning and to hand over to Mr. Otti by lunch, if not before.
Yeah, we need to finish by about 5 or 10 past 4, really, at the latest.
Right.
Please. So if that's going to cause an issue, then we'll just knock 10 minutes off lunch.
Right. Okay.
So have a think about that when we get closer to the time. And we were speaking for ourselves. I think we thought this was a relatively short appeal that should be through in the day.
Yes, that's certainly the plan. Yes.
Yeah.
Well, I'll crack on. The court will have seen that this appeal concerns a short but important point of statutory interpretation relating to the market study and market investigation provisions of the Enterprise Act 2002. I'm going to structure my submissions as follows. First, by way of introduction, I'm going to summarise the legal issue before the court and to explain our 2 grounds of appeal in outline. Secondly, I'll address the statutory framework. Thirdly, I'll deal with the factual position in the present case, that is the context in which the CMA exercised its power to make a market investigation reference in the present case, and the circumstances, and we say that the changes of circumstance which led to that decision after the CMA had initially decided not to make a reference. And fourthly, I'll make my submissions on the 2 grounds of appeal. If I can start by summarising the legal issue in a few propositions, the court will have seen that the CMA has the power to make a market investigation reference under section 131 of the Enterprise Act 2002. One route to making a market investigation reference is through a process known as a market study. That isn't the only route, but it is one route for making a market investigation reference. This appeal is principally concerned with the construction of sections 131A and B of the 2002 Act. And the CMA's position is that those provisions set out the rules for the conduct of a market study, including the time limits for making a market investigation reference as part of a particular market study. Sections 131A and B do not, on our case, establish any wider limit on the CMA's power to make a market investigation reference, in particular where the reference is not made as part of a market study. And if I can boil our case down to a sentence, it is that sections 131A and B are a code for the conduct of a market study, but they don't impose any wider limit on the CMA's vires to make a market investigation reference under section 131. That's the way we put it in paragraph 57 of our skeleton argument.
At some point, perhaps you could just help us with this, the relationship between the 2 powers, the 131 and the 131A, the market study, and then the broad power. When does the CMA use one and or the other? I mean, the 1A power starts with a section 5 fact-finding exercise, and it then goes through a series of procedural hoops to a decision within a time frame. And that's constrained by the time frame. The 131 doesn't start with a market study. It assumes a high degree of pre-existing knowledge on the part of the CMA. When does, just to understand the relationship between the 2, when does the CMA use one and or both?
Well,
the other?
So we'll look at the statutory scheme before very long. Section 131 is itself the vires to make the market investigation reference. So that's the vires. Whether it acts in a market study.
Where there's reasonable grounds.
Where there's reasonable grounds.
That's where that threshold test.
So there's if you like, there's an assumption there that that the CMA already has reasonable grounds. So as my lord says, it has a degree of knowledge which enables it to proceed to an MIR without having a market study.
Well, yes,
It might not.
Or it might or might not. Yeah.
yes, exactly. There'll be cases in which it's satisfied that that threshold is met without carrying out a market study, and there'll be cases where the market study is a route to gathering the information that it needs to decide whether that threshold is met. But what one sees when one looks at 131A and B is that they provide a framework for carrying out a market study, but they still rely on the VIRES in section 131 to make the market investigation reference. So it's a question of process on the one hand versus the underlying VIRES on the other. And we'll see that when we look at the scheme shortly. So that's our case in outline is that 131A and 131B are a code for the conduct of a market study. Apple's construction of the Act, which was accepted by the Tribunal, is that sections 131A and B do constrain the CMA's power to make a market investigation reference beyond a particular market study. The sections originate in a particular market study because they are triggered by the issue of a market study notice. But as we put it in our skeleton, under the Tribunal's interpretation, they impose an enduring constraint on the CMA's VIRES to make a reference after that market study is completed. That's the way the Tribunal's construction works, and that's Apple's argument. So those are the two rival arguments in outline. I'm going to develop three submissions in support of the CMA's construction. First, we say that our construction is the more natural interpretation of the time limits when sections 131A and B are read as a whole and in context. Secondly, we say that the Tribunal's construction leads to a poorly functioning and in some respects convoluted statutory scheme, which is unlikely to reflect the intention of Parliament. And I'll draw attention to a number of implausible and undesirable consequences of the Tribunal's construction. And thirdly, I'll respond to the argument that our interpretation allows the CMA to avoid the statutory time limits under sections 131A and B, which is one of the principal criticisms that's made of our position. And we say that there is no risk of the CMA evading the statutory time limits because of the constraints which apply under public law principles. I'll develop that argument. Mm-hmm. So that's a summary of the legal issue. Turning then to our grounds in outline. Ground one is the argument that I've just summarised. It's the essential issue of construction. Do sections 131A and B constrain the CMA's VIRES in the present case? Ground two concerns the application of the legal framework as we see it on the facts of the present case. And the court will have seen from the skeleton arguments that the CMA changed its view about whether a market investigation reference should be made in the present case because of what were, in the CMA's view, material changes of circumstance in the second 6 months of the market study process. And those changes of circumstance included, as we'll see, delays to the introduction of new legislation, which the CMA had anticipated using to address the competition problems which it had identified during the market study. And we say it was lawful, both in terms of the construction of the statutory scheme and as a matter of public law, for the CMA to decide to make a market investigation reference after its market study had been completed on the basis of facts and circumstances which arose after its decision not to make a reference. And we say it was proper, responsible and in the public interest for the CMA to react to those new circumstances and to reconsider its previous position. And just to be completely clear, this argument assumes that we succeed on ground one. It deals with a further stage of that argument, which is whether the CMA acted lawfully on the law as we say it is. The tribunal didn't get to this issue because it was against us on the question of VIRES, but we say that having wrongly found us against us on the VIRES question, it follows that the tribunal also wrongly rejected this part of our case. We've called it ground two because it raises distinct issues, but it does depend on ground one as a first step. So I think Apple's skeleton argument treats our ground 2 as if it were at least potentially an independent ground of challenge to the
Can I
judgment.
just ask you about that? The CAT seemed to assume that grounds 1 and 2 were connected in the sense that they took the in relation to point and said that that constituted a bar for the
Yes.
second investigation, but then sort of realising the consequences of that, said there is a quote way out,
Yes, that's right.
but that they couldn't see what that way out was.
Well, that
So they did accept that even on their analysis, there may be a get out
well,
in principle.
we'll see what their get-outs were. In my submission, they weren't really get-outs, and I'll develop those points. There are real problems with the CAT.
We understand that. I'm just that you suggest that the two arguments are completely different. That if you lose on ground 1, ground 2 doesn't arise. But the CAT didn't quite see it that way. They thought that if you lose on ground 1, there is still a get out, although they couldn't quite see what it might be.
Well, yes, but the get-out, our ground 2 is consequential on our ground 1. It's true that the CAT sought to identify ways through the problem, having found against us on the virus. But I'm assuming that if we lose on the primary virus point, that there's nothing for us to argue before this court about those issues.
Well, that's logical, because if there's no virus, there's no virus.
Yes, that's right. So we aren't following up on the CAT.
We're not following the CAT's hint.
No, well, when you hear my submissions, you'll probably see why we're not following the CAT.
And again, sorry to interrupt, but just as I understand it, again, just to get the structure right.
Yes.
Under 131, the broader power, there are the 3 conditions which have to be met. There's got to be reasonable grounds and none of the negative situations must exist.
That's right.
Do you accept that all that does is to trigger a power because of the may?
Yes, it's a discretion at that point.
It's a discretion. So those are preconditions to the existence of a power. Though one would have thought that if you meet those, there's going to have to be a pretty extreme set of circumstances before the power can't be exercised.
Before the power can't be exercised.
Yeah, so for example, I mean, if you meet, there's reasonable grounds and there's nothing to prevent, you then have a power. What would then prevent you from using that power if you've met those conditions?
Yes.
Chances are it would have to be something pretty extreme, for example, misuse of the power,
Yes.
something, subversion of the power for an improper purpose or something like that.
That's right. That is essentially
That's your
that's essentially our submission. The way the CAT approached it, and on Apple's argument, they say that the architecture of 131A and B sits on top of that and introduces a statutory constraint, and that's what we're here to argue about, my Lord. So we say it doesn't impose a constraint. Okay, so in fact we are now going to turn to the legal framework. If you could take out authorities bundle 1, and we're going to be in tab 1 for most of the next few minutes. The appeal is concerned with 2 forms of process, as I've said, the market study and the market investigation. The 2 processes are distinct. They are related to the extent that a market study can lead to a market investigation, but a market investigation doesn't assume that a market study has taken place. And I'm going to show the court the applicable framework as it relates to both processes. If we can start at AB1, this is section 5. This is, as we'll see in a minute, the underlying virus for carrying out a market study. And as the court can see, this vests in the CMA the very broad function of keeping various matters under review and gathering information to enable the CMA to take informed decisions and to carry out its functions. If you could then turn on to AB 12. One sees section 130A, which is a duty to publish a market study notice. And you can see in subsection 1 this refers back to section 5, which I just showed the court. This section doesn't actually define a market study. What it does is it provides that where the CMA wants to use its section 5 powers for certain purposes, it has to publish a market study notice. The purpose is defined in subsection 2 as to consider the extent to which a matter in relation to the acquisition of goods or services has or may have had effects adverse to the interests of consumers, and to assess the extent to which steps can and should be taken to remedy, mitigate or prevent any such adverse effects. So one can see that the purpose is defined in very broad terms, which on the face of it will capture most, if not all, market studies. And we'll see later on that the publication of a market study notice is necessary to enable the CMA's information gathering powers in section 174. And subsection 3 says what a market study notice must contain. It must define the matter, it must establish a period for representation to be provided, and it must state certain deadlines under the subsequent sections of the Act, which we'll come to. If we could turn over to AB 15, this is section 131, which I've already made some submissions about. This is the CMA's virus to make a market investigation reference, whether in the context of a market study or otherwise. And the section sits between two sections which are about market studies, but it's common ground that section 131 doesn't only apply in the context of a market study, and conversely, a market study is not only about a market investigation reference, it can lead to other outcomes. So the fact that this section sits here doesn't mean that there is an intrinsic link between a market study and a market investigation reference. It appears to be here because the next section refers back to section 131. The threshold test, which the court's already drawn attention to, is in subsection 1. The CMA can make a reference if it has reasonable grounds for suspecting that any feature or combination of features of a market prevent, restrict or distort competition in relation to the supply or acquisition of goods and services in the United Kingdom. And that is, on the one hand, it's a relatively low threshold test because it's reasonable grounds to suspect, and it's also broad in scope. And if that threshold is met, the CMA has the power to make a market investigation reference, whether it's carried out a market study or not. It is an important feature of the statutory scheme in my submission that the virus to make the reference is distinct from the provisions of the Act which relate to the conduct of a market study, and that is really the central reason why we say that the virus isn't defined or limited by the provisions governing market studies. And in this regard, subsection 4 on the next page, AB 16, is significant. This subsection places express limits on the CMA's general power to make a reference by carving out particular scenarios from the general power to make a reference. And we'll look at the first of those in a few moments' time. That is the section 156 scenario, which is covered by subsection 4A.
And you say it's surprising to say the least if the intention was that 131A would impose a fetter on the general power of 131.
Yes.
They didn't amend subsection 4 to say so.
We do say that, and we say that in particular because in fact subsection 4 was in fact amended in 2013 when these amendments were introduced. So the section could have said that no reference shall be made if the CMA has issued a market study notice in relation to the matter, unless it's issued another market study notice or something like that. But it doesn't say anything like that. And as I say, it is striking that the section was amended at the same time as 131A and B. If we could then turn on to AB 19, and now we look at the provisions which are central to the tribunal's construction. Section 131A is titled Decisions about References under Section 131 Consultation, but the heading of the section is actually broader than the subject matter of the section, because the section is only about decisions about references through the market study route. One can see that when one looks at the section. And there are also other provisions dealing with...
You're referring to the heading making of references, are you? Or
decisions, the headings, decision, I'm so sorry, the heading of the whole section A, decisions about references under section 131, consultation.
Yes, it's essentially about, that's the broad heading, that gives you the generic topic it's concerned with. It's specifically concerned with consultation.
Well, it's specifically concerned with market studies, actually. Yes.
Consultation about a market study.
Yes, exactly.
So you've got two procedural provisions in 131A and B. A is consultation, and then in consequence of the consultation, there's a time frame.
That's right. B introduces the time frame. That's right. Yes.
But from your perspective, the important point is they're procedural.
Yes, that's right. And the first point I was making was just a point about the whether the heading's a bit of a misnomer, because it looks more general than the subject matter, because the CMA can make a decision about a reference under section 131 without doing any of this.
Maybe a small point, but the way in which these provisions are being photocopied in our bundles, the headings are replicated. So if you go back to page 15, you'll see Part 4, Market Studies and Market Investigation, Chapter 1, Market Studies and Market Investigation.
Oh, I see. I'm sorry.
Making of references. That's then repeated in each of these sections, but the reality is it's not.
No, it's the section
So
heading.
these are all provisions under that part and that chapter,
You're quite right, my lord, yes.
which I think answers part of that point, really.
Yes. So I was just making the point that there are other provisions dealing with consultation outside the market study situation, and the CMA doesn't only make decisions about references under this section; it can make them otherwise. So it's just that the heading's a bit of a misnomer. The heading to 131A rather than the general headings. And what we see from the subsections is that the section is all about the conduct of a market study once a market study notice has been published to kick that process off. Subsection 1 applies where the CMA has published a market study notice and one is in one of two scenarios. The first is that the CMA is proposing to make a reference under section 131 in relation to the matter specified. The second is that a representation has been made to the CMA within the period specified in the notice that a reference should be made, but the CMA is proposing not to make the reference. So that will be a decision adverse to the interests of the people that asked for, the consultees that asked for the reference. And in either case, under subsection 2, the CMA shall publish notice of the proposal concerned and carry out consultation. And those obligations, as my Lord Justice Green's already observed, they're important because they feed into the time limits in section 131B. And we say that the natural reading of these provisions and the rest of section 131A and B is that they're setting out the steps that need to be taken within a particular market study. Where section 131A 1A refers to the CMA proposing to make a reference under 131 in relation to the matter specified in a notice, it's talking about a proposal to make a reference as part of a market study which is being conducted pursuant to a market study notice. And if one reads on through the rest of this section and section 131B, they are all in that vein. The two sections establish a step-by-step process under which the CMA publishes the notice, carries out the study, proposes to make the reference, and so on. And even 131A 1B is clearly about steps taken within the market study. We say subsection A should be read in the same way. So if I could then move on to B, section 131B at page 22. Subsection 1 contains the critical time limit for present purposes, where the CMA has published a market study notice in a case to which section 131A applies. The CMA has 6 months from the MSN, from the market study notice, to first give notice that it's proposing to make a reference, and secondly to start its consultation. And the points I've just been making about section 131A apply equally here. This is setting out the way in which the market study must be conducted. The section establishes deadlines to ensure that there's fair notice of and consultation on the CMA's proposals, to establish a clear, orderly process and so on, but this is all about the market study. And following the rest of the section through, subsections 2 and 3 deal with the case in which the CMA has published a market study notice, received no representations that a reference should be made within the period specified, and has decided not to make a reference. And subsection 3 that says that the CMA has to give notice of that decision within 6 months. That is the provision that was engaged in the present case, in the context of the market study the CMA carried out, because the CMA's view at the 6-month point was that it would not make a reference. And there's no dispute that the CMA complied with the time limits which applied to the decision which it in fact took in the course of the market study. The rest of the section from subsection 4 deals with what happens by the 12-month point, which is the publication of the report. That's the deadline for the publication of the report.
What troubled the cat was, I suppose, at base, the purpose of having a deadline here.
Yes.
So what's the purpose of having a deadline if you're right, the CMA can then go on and take another decision on the same factual matters that they have already been investigating, which is the relevance of those words in relation to. I don't know if you dispute that it's in relation to, in a sense it's all part of a continuum. There's probably no dispute about that. So what's the purpose of having a deadline here?
So what one can see from the two sections taken together, this is my code point, my lord. So the Parliament's clearly considered what ought to happen in the course of a market study, how the time ought to be used, what steps need to be taken to ensure that the process is fair, what steps need to be taken to ensure that persons who are potentially affected by a course of action are given the opportunity to make representations about that, and how the time that's made available to the CMA ought properly to be used, what balance ought to be struck. And you can see that what Parliament's done is it's allocated a maximum period of 12 months for the process. It's made provision that certain things should happen at the 6-month point, and in particular, it says, well, if at the 6-month point, nobody has made representations that there ought to be a reference, and the CMA is not minded to do that, then the CMA can draw a line at that point, and that then is a particular decision about the allocation of resources within that market study period. But none of that, in my submission, deals with the question of what ought to happen if there's a change of circumstance, for example. The fact that the CMA has been told through the statute to conduct the process in a certain way and to give notice of its position if it reaches a particular view at a particular point in time doesn't mean that if things move on, the CMA can't take a different decision for different reasons.
I'm sorry, I'm sure it's my fault that I've not been following your submission. My Lord's question was what's the purpose of the time limit? The question of change of circumstances, as I think you've already accepted, is a subsequent question of the analysis. So on the question of what's the purpose of a time limit, I mean normally the purpose of time limits of this kind is, putting it simply, finality. Would you dispute that the purpose of the time limit here is finality, and if so, what do you say the purpose is?
We don't dispute the proposition that the purpose of the decision is finality for the purposes of the market study. We accept that once within the market study, the CMA has made a decision at the 6-month point, that the intention of Parliament is that the CMA moves on, but that's why in my answer to Lord Justice Green I then moved on to the topic of material change of circumstance, because our case is that we made a decision within the market study process. The market study process ran its course, and then by the end of the market study it was apparent that there had been changes of circumstance. Now we don't say that we were entitled to change tack within the market study and to make a decision at the 12-month point of the market study that there should be a reference. We accept that would be inconsistent with the statutory scheme. But in my submission, if one treats sections 131A and B as setting out a code for the market conduct of the market study, all they do is establish what decisions need to be taken by when as part of that study. The question of what might happen thereafter is a separate question about whether the provisions of section 131A and B are intended to constrain the CMA's wider vires under section 131. So yes, the time limits within the market study process are final within that process.
Okay, but can I just ask one more question while the thoughts in my mind? I understand you say there's a distinction between the market study process and the wider power under section 131, but you also seem to accept the need to demonstrate a change of circumstances. So can you just help me on that? Because I can quite understand an argument to the effect of we accept that we have to show a change of circumstances. And there was a change of circumstances. And if that's to be challenged, that has to be challenged on public law grounds. And that's not been done. That's an argument I can understand. But that seems to be a different argument to an argument that says, no, the two things are completely unconnected. There's a wider power under section 131.
Yeah.
But if the argument is of the latter variety, there's a wider power under 131, then would not the logic be you didn't have to show a change of circumstances?
Yeah.
You could rely upon that wider power. It's not constrained by market study, and therefore you can do it all over again.
Yeah.
Can I just add to that before you answer? Because I think there's an important point here. You pinned your colours on market circumstance. One way of looking at this is to say, under the 131A, you've got two options. Either you decide there's no reasonable grounds for continuing, and you say within the time limit, no reference. Or you say there are reasonable grounds for continuing, but for, quotes, rational, end quotes, reasons, we're not going to do so.
Yeah.
And that, I think, is what you would say latterly you did.
That is right, Michael.
When you come back to 131, you've got the preconditions which then trigger a power.
Yeah.
So normally the power has to be exercised rationally, which might be because the reasons you already had were rational, or because there's a change of circumstance.
Yes, well,
So-
yes, that's right. So if I can start with Lord Justice Arnold.
That must be right.
Yeah.
You couldn't just sort of make an announcement make a decision you weren't going to make a reference.
No.
And then 5 minutes later say, well, we're still going to make a reference under section 131 with no rational reason for an inconsistency in a short period of time. But you say the position here is different because by the time you came to decide you would make a reference, you realised the government weren't going to pass the legislation anytime soon, and you had a whole raft of representations which you hadn't previously had.
That's right, but I do need to come back to Lord Justice Arnold. Yes,
No,
Michael, I do need to come back to Lord Justice Arnold's question. So if I can just explain the structure of our argument. We do say that the virus exists under 131, and we do say that sections 131A and B do not cut down that virus. The reason we've introduced material changes of circumstance is really twofold. First of all, in relation to the points that have just been made by my lords, to explain that we did have reasons for reconsidering a decision, and the decision was, as a matter of fact, made for sound, rational and principled reasons against the background of the decision that had been made beforehand. That's the first point, and I'm going to develop that point in a little while. But from the point of view of the legal argument, we don't say that there is a material change of circumstance gateway. What we say is that we were exercising our broad section 131 power. And what we say about material change of circumstance is that if there were to be a challenge to the exercise of that 131 power against the background of the previous decision, one would look at the rationality of it, of the decision, one would look at the reasons, one would look in particular at whether the CMA is acting in a way which appears to undermine the statutory scheme and undermine the fact that it's just followed a process and made a decision as part of that process. And we say that as part of that public law argument, it's relevant to look at the change of circumstance to say this is a decision the CMA was entitled to make. So that's envisaging a different limit, a different sort of legal limit on the CMA's power under section 131. It's a public law limit. It's common ground that in some respects that regulating this scheme depends on public law principles, and I'll show the court that. And the point we make is that public law, those principles, are also an answer to the problem which the tribunal perceived of the CMA making a reference here when previously it had decided not to. So I hope that answers your question, my Lord Justice Arnold, and also picks up on the points made by my other lords.
Well, I think this question is going to go on. Can I summarise your submission in this way? Does it come to this? You say that the applicable criterion is public law challenge, not violence.
Yeah, we say, properly construed, there is no statutory limit on our power to make a reference under 131 in this scenario, we accept that we're subject to public law principles, as my lord says, and that's why. And I'm sorry if I merged together two different points in my answer. But so my lord's question is helpful in unpacking the issues. But yes, my lord is right.
Okay.
So we were in 131B, and I'd got to the end of 3, and we got to the decision the CMA in fact made under subsections 2 and 3, and we were moving on to the remainder of the section. I can take this all a bit more quickly now. Subsection 4 deals with the CMA's report and says what that must contain, the findings of the CMA in relation to the matter specified, and the action which the CMA proposes to take. 5 sets out further requirements in a case to which section 131A applies. Now, this didn't apply to the CMA because the CMA wasn't in either of the situations covered by section 131A when it made its decision as part of the market study, so that section wasn't engaged. And subsection 6 says wherever a market study report contains a decision of the CMA to make a reference under section 131, that wasn't the case either, so that provision wasn't engaged either. Those are the core provisions for the purposes of the argument. I'll just briefly show you some other provisions. Page 33, these are the statutory questions that the CMA has to answer if a market investigation reference is made, and you will see that the question, I mean, there are variants on the question, but subsection 1 you'll see is similar to the threshold test for making a reference, but you're now answering the question, you're not just applying the reasonable grounds to suspect standard. And subsections 4 and following deal with remedies issues if an adverse effect on competition is found. Turning on, section 136 on page 38 provides in subsection 1 that the CMA shall prepare and publish a report on a market investigation reference. And if you turn on again to 43, section 137 provides the time limit for preparation of that report, which is 18 months with a possible extension for up to 2 years. Next point is at 57, and this is section 154, and this is an important point. This deals with undertakings in lieu. Under this section, the CMA can accept undertakings in lieu of a reference, and this power exists during the currency of a market study. So it's a way of bypassing the need for a market investigation reference and going straight to the question of remedy, and the parties prepared to do that. And we see from subsections 2 and 3 that in broad terms, the undertakings must remedy the potential competition problem, which has been identified as comprehensively as is reasonable and practicable. Now, the significance of this point is to be found in section 156, which is on page 60. And can you please read subsection A1, the first subsection? I think the court will get my point from just A1.
This is the exclusion under 131.
So that's right. So we saw that this scenario is excluded
If this happens, then a reference is excluded.
That's right. But what one sees is that under subsection A, no market investigation reference can be made if in relation to the same matter, if the CMA has accepted an undertaking lieu within the previous 12 months. So it follows that once the 12 months is up, the CMA can make a market investigation reference even where it has very recently accepted remedy measures which address the same competition issue. And we do say this is strongly at odds with the Tribunal's conclusion that once the CMA has carried out a market study, the statutory scheme heavily constrains the CMA's ability to go back over the same ground. If the CMA can re-enter the fray just a year later in a case where it's gone so far as to accept a comprehensive remedy, why should it be completely shut out from taking action in a case where it hasn't adopted any remedial measures at all?
It would still be constrained by the public law
Yes.
duty. I mean, subsection 4 of section 156 gives the example of being a breach of the undertaking. That's an obvious one where the CMA is then free to act. Make an MIR at that point. But you say there will be others.
Yeah,
if there were a change in circumstance, so that for whatever reason, even if there hadn't been a breach of the undertaking, somehow the undertaking was no longer effective in some way.
Yes, my lord, exactly. Absent a statutory constraint, those are the sorts of issues one would get into. So moving on to section 169, which is on page 63. This imposes a duty of consultation in relation to relevant decisions which affect the interests of persons, and the duty of consultation is in subsection 2.
Sorry, just catching up. Section 169.
Section 169, page 63. So this is a duty of consultation in relation to relevant decisions. And what we see is that subsection 5 carves out from the duty to consult under this section a scenario where there is provision elsewhere in the Act for consultation. And subsection 6 defines a relevant decision, amongst other things. One sees this on 64. And relevant decision means, under A1, a decision to make a reference under section 131 in a case where the CMA has not published a market study notice under section 130 in relation to the matter concerned. And there's no obligation to consult under this section if the CMA has issued a market study notice, and that makes obvious sense because we've seen that if the CMA issues a market study notice, there's a separate duty of consultation which operates within the timeline of a market study. So there's no need for section 169 to apply in that case. So this section doesn't define or limit the CMA's power to make a reference, it just defines the scope of the duty of consultation. And then just two sections which I will introduce because they are part of Mr. Otti's argument. Section 174 on page 70. This contains the CMA's mandatory powers to gather evidence which may be engaged both in relation to a market study and in relation to a market investigation. The powers were extended to market studies when the constraints under sections 131A and B were introduced. One sees that in section 1741A. It's part of Mr. Otti's case that the time limits were a quid pro quo for the grant of new powers, and that is true, but there is no question that where these powers have engaged, the CMA now has only 12 months from the issue of the notice to use them. Previously, a market study was unlimited in time. Where the notice is issued, there's now a hard stop at 12 months. So the powers clearly are time limited. That quid pro quo doesn't tell you anything about whether the CMA has a power to make a market investigation reference in different circumstances which don't engage its mandatory information gathering powers, which is the situation we're concerned with. And finally, I will just show you, although I don't make any points about section 174A at page 75, which is the regime for the enforcement of section 174. And Mr. Otti makes reference to that too. So that's the legal framework. I'm now going to move to the factual matrix of the present case. And the court will have seen from our skeleton that a key feature of the background in the present case is the government's plan, which is now coming to fruition, to vest new powers in the CMA as part of a new pro-competition regime for digital markets. And I think the best way to show the court that is in the government consultation document at supplementary bundle 554. Now this dates from July 2021, which is actually 1 month after the market study notice was issued in the present case. But before this document, there have already been a number of prior consultations dating back to 2019.
Sorry, which tab?
Tab 5. So there have been previous consultations before this, but we can pick matters up at this point, which is roughly contemporaneous with the market study notice.
We don't know whether this is going to be in the King's Speech on the 7th of November, do we? The Act.
There is now already a bill.
The bill.
Yes.
Do you know what its likelihood of being passed is? Is it going to be in the next full session, do we know? Or is it in the parliamentary procedures?
My instructions are that the current, I mean, we live in uncertain times, but the current expectation is that the Digital Markets Competition and Consumers Bill will be passed at some stage in the first half of 2024, and it will come into effect at some stage in the second half of 2024.
And does that mean if it's not in the King's Speech on the 7th of November, do you know what its fate will be? I'm just interested, I mean, it's not yet got royal assent.
No.
It's in the procedure. But as you say, we live in uncertain times, and there's a great deal of debate about what's going to go into the King's Speech, or what isn't going to go in, and what may flounder, and what may not flounder. Maybe your clients just don't have that intelligence or don't want to gossip.
No, I don't know if I can help you, my lord, with that question, but I'll find out if we can.
Is it one of these bills that can be carried over to the next legislative session? Because some bills drop and some bills don't.
I think
because the bill has already been introduced.
Yeah, the bill was introduced on the 25th of April of this year, and it does contain, broadly speaking, the pro-competition regime. So, and that's moving forward. Those behind me will have heard the court's questions, and if they can help, they will.
Maybe it's a matter just of curiosity rather than relevance. From your point of view, we have to examine from a public law perspective whether, at the time the decision was taken to start the procedure afresh, it was rational.
Yes.
That's at least what you would say. This is the way to look at it.
Yes.
To take the view that things had not progressed sufficiently at that point in time. We're not looking at it as of today.
No. At the end of my submissions about this, I was going to say, if the court is curious, the position is as I've just described it. But I was also going to make the point that this is all after the event and not relevant to the legal issue.
Anyway, we're looking here at an earlier point in time now.
Yes, this is roughly contemporaneous with the market study notice.
Yeah.
And one can see the executive summary is on page 57. And one can get a flavour of the nature of the regime and the state of play from this document. So could the court read paragraphs 4 and 5? So we can see there's going to be a new pro-competition regime for digital markets, which is going to be run by the Digital Markets Unit, or DMU at the CMA. And one can see from paragraph 6 over the page that the new regime is targeted at firms which are designated as having strategic market status, or SMS for short. Get that from paragraph 6.
I'm sorry to pepper you with questions. At this time, the EU equivalent was just in force. When did the Digital Markets Act come into?
It's not in force until
it's adopted. Is it not yet effective?
Correct. It comes into force in.
Yeah. So Professor Bailey says it comes into force in April next year. But you'll see when we go through some of the later documents that the two processes were there or thereabouts. But what we see is that the UK starts to fall behind the EU timetable.
Yeah.
Paragraph 6 is SMS status, and paragraph 7 is important. Firms with SMS will be subject to an enforceable code of conduct which will set out how they're expected to behave. So one can see that this is ex ante conduct-based regulation for pro-competitive purposes. It's quite different from antitrust enforcement under the Competition Act, which is ex post and deals with anti-competitive behaviour, not pro-competitive behaviour. And it's also different from the use of a market investigation power, which is about identifying problems and solving them through one-off remedies. This is a different sort of regime which is targeted specifically at digital markets. Paragraph 11 on this page deals with next steps. And one can see in the 2 lines up from the bottom that the government will consider responses and take them into account when finalising proposals. So it does look like it's a matter of when and what powers the CMA is going to get, not whether it's going to get them. If you turn on to page 60, paragraph 16 gives the court a bit of a flavour of how this is a different sort of regime. It's talking about a contrast with competition enforcement cases which are slow and take many years to conclude, but by the time competition concerns are identified and addressed, a digital firm's market power in a fast-moving market can become more entrenched and the economic damage irreversible. And you see from the first line of paragraph 17, the government has therefore decided to set up a new pro-competition regime which will proactively shape the behaviour of digital firms. Turning on to page 63, paragraph 23 and 24 again give a good sense of the state of play. The first line of paragraph 23 says that the government is committed to establishing a dedicated DMU, and it goes on to explain what the DMU is. 24 is important. It says the DMU will be part of the CMA. This will allow the DMU to harness the CMA's existing competition expertise and reputation, and so on. And one sees the last sentence, the DMU was set up in a non-statutory form within the CMA in April 21, so this is going back a few months and in advance of the statutory regime, to support the rapid establishment of the statutory regime. So there's a strong sense that the regime will be up and running soon. Page 90, the last one page in this document, and one can see from paragraph 195 on that page that the consultation closes on the 1st of October 2021. So that's the creation of the DMU in outline and the new regime. If I can now turn back to the processes which are the immediate focus of this case. Tab 3 is the market study notice, which initiated the mobile ecosystems market study on the 15th of June 2021. And for the court's note, one can see the matter defined in paragraphs 1 and 2. And the deadline for representations is in paragraph 4. And it's as soon as the 26th of July 2021, which I think is 6 weeks. And that is because, as we've already seen, the CMA has to take a position on various matters by the 6-month point. So it's a very compressed process. It's a very short deadline for representations. Subsection 4, I beg your pardon, paragraph 3 refers to a statement of scope, which is at the next tab, and I'm going to look at that now. This is also dated the 15th of June. And if the court could turn to page 42 and read paragraph 25 on that page and 29 on the next page.
it's probably for the. Can we? Turn down.
I think we need the digital markets unit.
When in doubt, unplug it, I think is the answer.
Well, we promised dedicated digital support staff in the near future, so we'll test that in due course.
Luckily, it seems to be a non-essential microphone. So we were looking at 25 and 29. I don't know if the court's seen those. And then last reference in this vein under the heading Context for the Market Study is 31 on page 44. And these are all really making the same point. It's a key purpose of this particular market study to prepare for the operation of the DMU and the new pro-competition regime. One sees then in 33 some of the background in terms of the creation of the new regime, and 34 refers to the impending consultation document, which we've already seen came 1 month later. And I think it makes most sense for the court to read paragraphs 35 and 36, which run from pages 45 to 46. So the market studies will enable the CMA to make initial assessments of strategic market status, to think about codes of conduct, and the overall purpose per the last few lines of 36 is to enable the DMU to hit the ground running. So clearly anticipated that powers are on the horizon. The CMA needs to get ready for the new regime at some speed. Page 51, SB 51. There's a heading Potential Remedies, and paragraphs 152 and 153 reiterate the points we've just seen. Paragraph 154 is a bit different because it again talks about informing SMS designation and supporting development of codes of conduct. And then what you see towards the end of that paragraph, where we consider it appropriate, we may take alternative or additional courses of action to address any concerns that we find, which we do not consider would be appropriately addressed by the new pro-competition regime. These include making recommendations to the government for further legislative reform, making a market investigation reference, and so on. So all options are open, including a market investigation reference, but the purpose of laying the ground for the new regime is front and centre in all of this. 6 months later, the CMA published its interim report, which we see at tab 6. And this sets out the CMA's reasons for deciding not to make a market reference at this point. We can take them largely from this executive summary. So we're now into the territory that we started to identify in the exchange of my laws, where we're looking at the CMA's reasons at this point as compared with the reasons that we'll see in due course. And on page 105, at paragraph 32, the CMA sets out the summary of the competition concerns it's identified up to this point. I won't go into this in detail because there's a lot of it. There are 4 themes. I'll just pick out a few paragraphs to give the court a flavour on points which tie into points which became more important later on. If the court looks at theme 3, which starts on 110, and if the court reads 47 and 48, one gets a flavour of the concerns the CMA had identified at this point in relation to mobile browsers and mobile browser engines. It's page 111. So that's a flavour of the substantive concerns. If one turns on to page 115, one sees a section headed Initial Views on Strategic Market Status, which is self-explanatory. That's the threshold for the DMU powers to be engaged. And the conclusion at 64 on page 116 is that the initial assessment is that Apple would merit SMS designation in various respects, including in relation to browsers and browser engines. New section starts at 66, initial views on potential interventions to address competition concerns. Various possible interventions are identified. We won't go into those. That runs on for several pages up to 122. And if we could pick it up again on page 123 and look at 88 and 89, what one sees in summary is that the DMU is likely to provide a means of implementing the interventions that the CMA has identified. When I say the DMU, I mean the new pro-competition regime is likely to provide a means of implementing the intervention the CMA has identified. And there's a conclusion on that point at paragraph 91. So if assuming the DMU comes through, the new powers come through, the potential interventions that the CMA has identified, the concerns identified, it looks like the DMU is a route to doing that. So there's then an important section from 92 to 97, which is the CMA's decision whether to make a market investigation reference at this point. One sees from paragraph 93 that importantly the CMA takes the view that the threshold test in section 131 is met. So that's paragraph 93. Paragraph 94 says the CMA nevertheless has a discretion whether to make a reference. That's my Lord Justice Green's point about it being a power. And 95 notes that there have been no representations proposing a reference. And that, in my submission, is not wholly surprising, notwithstanding the concerns that have been identified, because the statement of scope made clear that the CMA has in mind using different powers in this case. 96 reaches the conclusion that the DMU will be best placed in principle to tackle the concerns that have been identified to date, and 97 sets out the decision not to make a reference. But it does go on to say that the decision will be kept under review in the remainder of the market study. And one can see in footnote 36 at the bottom of the page, we may revisit our present decision if legislation required to bring the new regime into force is substantially delayed, and so on and so on. So I pause there. Mr. Otti says that the CMA's decision to make a market investigation reference in the present case was a volte-face. That's paragraph 43 of his skeleton. And we say that is a serious overstatement. It is true that the CMA changed its view, but that was in a context where the CMA said it would keep matters under review, and it specifically said in this footnote that one of the reasons it might do that, it might change course, is if the DMU powers were delayed. And it isn't just a footnote point, we'll see it in the main body in a moment. The tribunal seems to have had a concern that in saying this, the CMA was trying to reserve to itself powers which it didn't otherwise have. That's paragraph 58 of the judgment. And that, just to be clear, that isn't part of our case. We don't say the CMA...
Well, if it's right, it's right. It's wrong.
Yeah, this is not the CMA trying to conjure up a virus it hasn't got. This is just the CMA explaining its thinking at this point in time. So the reservation of right is not. There's no argument that the CMA reserved its position and so on. This is just descriptive of the CMA state of mind. Just a couple more paragraphs in the main body of this document. On page 132, start of 910. Well, perhaps you need to pick it up at the end of 9.9. Our intention was also to help further the thinking on key elements of the regulatory regime, such as code of conduct. On the basis of the progress that has been made towards establishing the new regime, this continues to be the CMA's intention. So again, forward momentum. For the court's note, paragraph 911 on that page gives further reasons why the DMU is best placed to identify to address the concerns, and 912 makes the footnote 36 point again on page 133. So
they expressly say in 912 that one of the reasons for leaving the point open is the possibility that the legislation
exactly that's the
here for some considerable time, and
That's right.
they're flagging the fact that they may yet make a market investigation reference in those circumstances.
exactly right. So that's the point we saw in the footnote, but it's there it's very clearly in the main text in paragraph 912. So over the page, tab 7 is the decision not to make a reference. One sees that on page 140, paragraph 6, and 8 is in similar vein to paragraph 912 that my lord just highlighted and the footnote. It's this should not be interpreted as the CMA finding no concerns in this sector, only that any potential concerns would not be best addressed through a market investigation at this time. So that's December 2021. The mood changes as one moves into 2022, and I now want to show you tab 13, which is evidence given by the then Chief Executive of the CMA, Dr. Andrea Cacelli, on the 8th of February 2022.
Yeah.
This is one of the documents that was added late last week. And just to give you a flavour of this, at the bottom of 296, there's a question from the chair, which is Baroness Stoll. And it probably just given this is quite dense text, it probably makes sense for the court to read the chair's question and then the first and third paragraphs of Dr. Cacelli's response to the question.
Sorry, we're reading from starting at
296,
296.
bottom, the chair.
Sounds very busy.
It sounds very busy. The court can stop at thinking about the trade-offs of possible interventions.
Yeah.
In evidential terms, what does this add?
So all I'm really showing is a change in the mood music, because toward the end of that paragraph, this is why we're hoping to use the DMU legislation. If there's a continued delay, which is the current position, we will actively discuss it. So the CMA is now starting to express concerns about delays to the legislation.
That's the relevant.
That's
It is really delay and nothing else.
No, that's all. That's the only reason I'm taking the call to this document. And one sees more to that effect from the bottom of 300 through to...
Sorry, so we measure, insofar as you're right in the analysis of the Act, we measure rationality by reference to what we've seen. We measure change of circumstance by reference to delay.
I think what we say is the court looks at the reasons
If
why...
your position as set out at the time was rational,
Yes.
you may say that's the end of it. In any event, you say that the change of circumstance was the fact that, contrary to your expectation, the Act did not come into force.
That's one of the changes of circumstance, and in the
Yeah,
context of everything we've
solutions.
seen, it's a very salient one. But the real significance of change of circumstance, we say, is to cut to it, is Apple says there are time limits, and you're abusing your powers by taking a decision under the time limits and then changing your mind. And we say that the answer to that is that, well, if the circumstances change, then it isn't. We aren't abusing our power. We're using our power for a proper purpose, having regard to the then prevailing circumstances. So that's really why we bring it in as part of the public law argument. And I won't ask the court to read it because it'll take time. But there's more to similar effect from the bottom of 300 through to 301, ending at the beginning of question 14. 300. The chair says, "I'm keen to understand." And then there's another response from Dr. Castelli, which is again raises the concern about delay at this point. So that's February. Next milestone, 6th of May 2022, is the government's response to the July 2021 condoc. So this is now 10 months after the consultation document and 5 months after the interim report. This is tab 8. And we don't need to spend much time on this. If you turn to page 144, one can see that the plan does appear to proceed with the new regime. It appears on the face of this document because it says we are now confirming the design of the new regime. But if one turns on to paragraph 16 on page 146, it says the government will bring forward legislation to implement these reforms when parliamentary time allows. So it's completely open-ended. What did that mean in practice? The Queen's speech was published a few days later on the 10th of May, and it didn't contain the bill to establish the new regime. And we get a bit more colour from an FT article at tab 14. I won't go to it now if the court would like to look at it in due course. What one sees from that is there is even speculation based on an assessment of what the government might think about whether the new regime will happen at all. The court will probably look at that in due course if it's minded to do that. So I think what we can certainly say is that the momentum that we saw in the earlier documents has now stalled and things aren't moving forward. So that's the context for the final report, which we see at tab 9. And this is the 10th of June. If we can pick it up on 186. This says that the CMA has decided, sorry, I beg your pardon, paragraph 913. We have now decided to consult on making a market investigation reference. So it's not purporting to make a decision to refer within the market study for the reasons I've already touched upon. It's simply explaining its thinking that it's now minded to consult. That consultation is actually separate from this document, but because the CMA has changed its view, it explains its position in this document. And 914 refers to the important developments since we published our interim report. Now the court will have seen this in the skeleton, so I won't take it too slowly. But in short, the first point is that parties, including browser vendors, had urged action now in response to the interim report. So this is a call for action, but more specifically, it's a call for action now. So it's a question of timing. The next two bullets give further detail about what parties have told the CMA about, on the one hand, browser issues, and on the other hand, cloud gaming, which is the other topic, which was the subject of the reference in due course. The fourth bullet addresses further work which has been done by the CMA in relation to the practicability of intervention. Now, Apple says this work could and should have been done by the 6-month point if it was salient to the CMA's position. And we simply say that a market study is a 12-month process. Any diligent decision maker is going to have done more analysis and be better informed at the 12-month point than at the 6-month point. And so the CMA had more information at this point, and that went into the mix. And then there's the final bullet.
Even under section 131A, a market study is the precursor to a consultation, which is the precursor to an actual reference. A decision is only made at the end of an actual reference, so we're looking at something which is 3 stages back. So there's, in terms of the height of the threshold that has to be met,
Yeah.
you're sort of the preliminary investigation leading to a consultation which gets more information,
Yeah.
which then leads to a decision to refer or not,
Yeah.
which itself is an investigation,
Yeah.
which then leads to a decision. So it must have some bearing on.
And of course, the market investigation is not the only possible output of the process. So notwithstanding
Could be undertaken.
notwithstanding that the CMA took a view at 6 months, the work goes on for other purposes, and so there was more information available. The CMA didn't shut its eyes to it. So, but the last bullet is particularly salient in the context of everything we've seen. So the government does intend to bring in legislation for the DMU, but we now understand this will not be in the current parliamentary session, i.e. within the next year. We say that the significance of that is obvious against the background of everything the court's seen about the approach to this market study. The consultation document is at the next tab, tab 10. It's the same date as the final report, but the consultation is not part of the market study, it follows it. So as the market study ends, this new phase begins. And one of the issues between Apple and the CMA is whether this consultation and the subsequent decision to refer were taken outside the market study. And we say clearly they were. Of course, the market study, the market investigation reference has its origins in work done in the market study, and we of course accept that. But neither the consultation nor the decision to refer were part of the market study process. They are distinct legal steps which come after the 12-month period is over. And I will come back to that point. And then just to complete the picture for the court, that the decision to make the reference is at core bundle 6. We don't need to go into that. There's no challenge to the substance of that decision. It's only a question of timing. So pulling the strands together, we've seen that a driving purpose of the mobile ecosystems market study from its inception was to facilitate the use by the DMU of the new legislative powers it was expecting to obtain, and to allow the DMU to hit the ground running. And consistently with that starting point, the CMA decided at the 6-month point that although the threshold for a market investigation reference was met, the DMU would be better placed to address the concerns which have been identified than a market investigation reference. By the 12-month point, things had changed in 2 main ways. First, on the basis of further representations received and further work done, there was a stronger case for the CMA to proceed with a market investigation in relation to 2 particular areas, that is mobile browsers and cloud gaming. So that's the first point. The second point is that, as we've seen, the DMU powers were the subject of unexpected delays, and so they were no longer on the horizon. So the route by which the CMA had planned to address these issues was no longer immediately available. So in those circumstances, the CMA took a different view as to whether a reference should be made in relation to those 2 topics. Against that background, I can now make my submissions on the 2 grounds, although I've covered a lot of the ground already. So when we looked at the Act, I made my central submission on ground 1, that the natural construction of 131A and B is to establish rules, a code for the conduct of a market study, not to cut down the powers that are otherwise vested in the CMA. That they create a code starting with a market study notice, ending with the report, covering the various stages in between, and every subsection contributes to and makes sense within that framework. And we say, of course, the sections should be construed together and as a whole. And read in that way, the sections clearly do constrain the CMA's power to make a market investigation reference within a market study, but it isn't natural to read the provisions as imposing a wider limit on statutory powers which exist and operate outside the framework of a market study. And the Tribunal's construction has two significant and in our submission, unlikely consequences, which one doesn't get from a natural reading of sections 131A and B. The first is that the sections impose what we've called an enduring limit on the CMA's vires, which is triggered by non-compliance with the time limits which applied in relation to an earlier market study. We say that is a really odd and unlikely way to define the limits of the CMA's vires. It is a strange, convoluted rule that to decide if the CMA has vires, one goes back to a market study notice that was adopted in a different process. One counts 6 months and asks whether the CMA issued a notice and started a consultation within the time limit which applied in that market study. And it's especially odd in our submission, because if the CMA carried out an earlier market study and it didn't make a reference at that point, then almost by definition the CMA won't have complied with those time limits, because that's why one is back now again contemplating making a reference at this point. So
when you say not comply,
yes,
you mean comply. I mean, you complied with the time limits of 131B.
yes,
You say you start, the clock starts again.
yes.
Apple says, well, you ostensibly complied, but we now know with the benefit of hindsight you didn't comply.
Well, perhaps I just need to show you the judgment on this point, just to crystallise this point, because what the judgment says is one has to read these time limits. So this is core bundle, tab 4.
Yeah.
And paragraph 44 on page 72. It says, if, as we find to be the case, section 131A applies, certain consequences follow directly from the clear words of the Enterprise Act. And we then, so what the tribunal then does is it applies the time limits that apply under section 131A and B.
Can I just stop you? When I read those, I wondered what the meant as we find to be the case. That relates to paragraph 43.3.
That's right.
Because it's in relation to the matter.
That's right.
But in relation to the matter in 131B is simply a precondition of a duty to consult. That's its statutory purpose. It's a procedural condition within that provision about notices, market notices. It doesn't, on its face, confer a limit on anything else other than the duty to consult. It's just, that's what triggers the duty to consult. Which is, and I found, when I looked at the words, as we find to be the case, I was wondering what was it that meant that they were essentially treating the new decision as really, in some way, a disguised old decision.
Yes.
Or a reversal of the old decision. And it seems to be the words in relation to in 131A.
Yes, well, I think what the tribunal does is it says, well, look, this is the same matter.
Well, it's in relation to the same matter.
That's right, it's in relation to the same matter.
Which you agree in one sense.
Yes, exactly.
And the only words, and the only place you get that is in language in 131A, in relation to the matter specified in the notice, which is what 43, subparagraph 3 of the judgment says.
Yeah.
Yeah.
So I think that's what they're referring to as we find to be the case. That is because it is in relation to.
I think my lord,
sense.
yes, I think my lord is making essentially the point we make, which is that really what the tribunal is doing here is it's transposing these procedural provisions which apply in relation to a given market study, and it's construing them as creating some sort of supervening limit on vires. And we say, well, no, when you're going through that process, you have to follow that process and you have to follow those time limits. But then when you
go back and actually look, what are the words in relation to?
Yes.
What do they serve in the statutory framework? At the moment, they're no, as on one view, they do no more than trigger the duty to consult. That's the function of those words in the statutory provision, as on one view of the way they could be read. When if you look at the annex to the judgment, shorthand for where 131A is.
Yeah, I mean,
The CMA is proposing to make a reference under section 131 in relation to the matter specified in the notice.
Yeah,
Then 2, the CMA shall publish the proposal and consult.
Yeah, Yeah, that's right. So in the process provisions, that's where it appears. The language does also appear in 131A1A, and I think this is what the tribunal
That's what I was
does.
looking at, yes.
So what the tribunal does is it says, well, this is in relation to the matter specified.
Yes.
So we now lock ourselves back into the old timetable. And they say, well, you didn't comply with that timetable. We say, well, of course we didn't comply with that timetable, because in that process we decided not to make a reference. But it doesn't make sense now to go back to the timetable that applied in that study and say, well, you didn't comply with the time limits. That's obviously not how the provision should be construed. It's nonsensical.
Perhaps where I'm coming from is this: what is the logic of the judgment?
Yes.
How do they come to the conclusion that they can, so that they can say, as we find to be the case, 131A applies? That appears to be because of their analysis of the words in relation to. Because in a broad sense it's correct, your new decision is in relation to the old, it's a continuation of the same facts. So you therefore have to ask yourself, what do those words in relation to the matter specified actually serve in Parliament's view? And on one analysis of this relevant statute provision, they're no more than one of the conditions precedent for the duty to consult. That's their function.
Yeah.
They're part of a mechanism, a modus operandi for a consultation.
Yes.
It's not really substantive.
No, I mean, yes. I mean,
And then we ask ourselves the question, do they serve then to limit the power in 1311?
yes, exactly right. We say it's perfectly.
The oddity, it's maybe making the same point, but on the basis that, and I agree with my lord, that 44 opening line appears to be a reference back to 43 sub 3.
Yes, that's right.
As to why section 131A 1 applies. And then they say in 44 2 and 3, they set out the table of the time limits under section 131B, and they say, well, the CMA's failed to comply with those time limits. And that seems, at least at that stage, to be predicated upon the idea that the CMA made a decision to make a reference, but of course the CMA hadn't made a decision.
Exactly, Myron. Exactly.
And then the tribunal pick up after 1, 2 and 3 at the end of that paragraph at page 73, they make the point, well, this is actually rather unfair to the CMA because their decision had been not to make a reference.
Exactly. And
So there's a complete illogicality in the analysis, because if that's right, then what are they doing talking about those time limits at all?
I completely agree, my lord, that passage at the end of page, internal page 23, bundle page 73, is really recognising the force of the submission I'm making,
Exactly.
which is that these time limits just didn't apply to the decision that was made at that point.
If you
in
made
time.
a decision not to make a reference, then at a later and if you're right that there's nothing in those two sections, 131A and B, which precludes the general power under 131 if the conditions for that are satisfied. Then the fact that after all the 131 decision not to make a reference, you then make a further decision to make a reference under 131, subject to the public law, doesn't seem to me 131A and B constrain you from doing that.
That's our case.
The only other place that the CAT refers to these words is in paragraph 55. And then they say we didn't hear argument about the precise meaning of the words in relation to. Is that correct? Was this something which the CAT thought of for themselves?
Well, I think that I mean, as I understand, I didn't appear below, as the court probably knows, but I think, as I understand it, 43 really reflects the analysis, which is that they have looked at the subject matter of the reference. They've said this is basically the same or a subset of it, one can look at the language of 131A, 131A1A, and in a mechanical way say, well, it sort of maps onto the situation here, because the CMA is now proposing to make a reference in relation to that subject matter, but it hasn't complied with the time limits. This is precisely the point my Lord the Chancellor made to me. But we just say that's completely divorcing the language from its context, which is the steps that need to be taken in that process. And we're now outside that process. Yes.
And so in 55.1, when the CAT says, we do not consider that the CMA can contend that the decision falls outside the scope of these words in relation to, and you don't. I mean, logic tells you there is a causal connection in time.
Yeah.
But that means you've really got to go back to what those words in relation to the matter specified in the notice are serving in Parliament's contemplation
Yes.
in the Act. In your cases, they're just simply procedural as a trigger for a consultation.
Yes,
They
they're
don't have
procedural.
broader
They're
implications.
procedural as the trigger for two things. First of all, I think, well, sorry, there are two steps that need to be taken. There's the giving of the notice of the proposed reference, and there's the consultation that's consequential on that. And we say that it's all just triggering that process within your market study.
It must be inferred from the catch judgment that they assume that it is an additional limit on 131, even though it's not set out there.
Their view, as I understand it, is that these time limits have significance, and one has to give them supervening force. And we meet that point by saying, well, they have significance, but they have significance within the process to which they apply. But once the process is completed, one doesn't go back and then transpose those time limits to action taken on a different basis. So that's the first
The
option.
process to which they apply wasn't actually being triggered.
No.
Because of being a decision not to make a reference.
Exactly.
That was the context of the market study. Quite apart from what you've shown us as to what the purpose of the market study was, which is to gather information to enable them to run the DSUs properly. When it eventually came along, and as they say in one of those documents, they could hit the ground running.
So that's the first oddity. It's this transposition of the time limits from
Before we allow you to get on with the thing, just trying to think this one through. If you're right in the overall structure of 131, it all just tracks back into the word may, the power. Was this reasonable and or rational and or a change of circumstance permitting the exercise of the power?
Yeah, we don't shrink from the fact that because the CMA made the decision it made at 6 months, one has to look at the subsequent decision and consider whether it's a lawful decision in the broad public law sense to make it. We accept that, but we say that when one looks at the context, and the reasons for making a decision to make a reference, having previously decided otherwise, I mean, it's self-explanatory really, but what the tribunal's approach to Vires means that it just cut itself off from looking at that.
As I understand it, what was being argued against you was a Vires point.
That's right.
About jurisdiction.
That's right.
It wasn't being said, well,
No.
even if you have jurisdiction, you've exercised it improperly in some public law
That's
way.
right. And in fairness, we have raised a risk of confusion to some degree. We've raised the material change of circumstance point because we recognise that having taken one decision and then taking a different decision, the court will want to understand, well, what are the safeguards here?
I think where we've got to on that, and correct me if I'm wrong, is actually that issue doesn't arise. Because this is pure jurisdiction, pure Vires. There never was a rationality challenge. And therefore, it's binary. Either there's jurisdiction and there's Vires, or there's not.
Yeah, well, that is right, my lord. But we thought it was important to show the court that if one accepts our case on Vires, what are the safeguards then against the CMA having bite after bite of the cherry? We just thought that's a matter of importance for the court understanding how the scheme works and what safeguards there are for affected parties. Now, my lord is right analytically that the question begins and ends with Vires, but we've developed the submission. And it in part arises because on Malone and Friends case and on the tribunal's construction, these public law principles come into play in a way I'm just going to deal with actually in a few moments. And so there's then a point about internal consistency, because we say, well, look, if those principles apply in situation A, then that's the appropriate safeguard in relation to situation B. So they do arise out of the tribunal's reasoning as well, my lord. So the second oddity is that on the tribunal's construction, once the CMA has issued one market study notice and decided not to make a reference, sections 131A and B then force the CMA to go down the market study route again if it wants to make a market investigation reference. And I'll show you that in the judgment. It's page 76 of the core bundle. 53, last line of the general part. The consequence of our decision in this judgment is that the CMA can only make a standalone reference where it is not in relation to the matter specified. That's my lord's point. And then it says only make a link to reference under section 131 where a fresh market study notice is made. No doubt a fresh market study notice can build on the findings of an earlier market study notice The fact is that a series of market studies on the same or very similar subject matter may well be within the vires of the CMA, but may well be challengeable on other public law grounds. So what this means is the CMA can potentially start a market investigation reference in relation to the same matter after completing a 12-month market study, but it has to issue another market study notice, and it has to go through the hoops of this process again, which could take up to 12 months. And as a matter of language, we say if the purpose of the Act had been intended to constrain the CMA's vires in this very specific way, in this very surprising way, one would expect to see clear language in section 1314 or otherwise. And we don't see that language, but we do go further than that, say actually the finding in 53.2 is counterintuitive and it doesn't make policy sense. Once the CMA has carried out a market study, it is less rather than more likely that the CMA will want or need to carry out a further market study as the precursor to a market investigation reference, because it will already have done that work and gathered the information. So that's the CMA's position. From the perspective of industry parties, carrying out a further process of up to 12 months would obviously heighten the burden on them, and it would re-engage the CMA's compulsory powers for another 12 months before the market investigation of up to 18 months. So we say that this construction doesn't make policy sense from anyone's perspective. And in fact, one sees the tribunal's reasoning on this point break down in the judgment at 49 and 50. And this is on page 75. Now, the tribunal says in 49, tying the reference to the study it arises out of in this way makes perfect sense for a number of reasons. And they then make a number of points which we don't actually disagree with, because it's true that sections 131A and B set out a coherent code under which a market study can lead seamlessly into a market investigation reference. But it doesn't follow that those are the only circumstances in which the CMA can make a market investigation reference. And the tribunal's reasoning proves too much, because if the court could read paragraph 50 against the background of the submissions I've just been making. So the point we make is that if the CMA is only entitled to consider a matter, to quote, once and not time after time, then there's no reason why it should be able to issue a second market study notice either.
Well, paragraph 50 is completely inconsistent with paragraph 53.2, isn't it? Because 53.2 is contemplating you can have another.
Yeah, exactly.
You can have a market investigation reference, but only if you have another market study.
Yeah,
if we have another market study notice, albeit you can only do that if it's not challengeable on public law grounds.
Yes.
And yet 50 is saying is once you've had one, you can't have another
Yes,
one.
we make 2 points. First of all, it's internally inconsistent in the way my lord's identified. And secondly, if the purpose of these provisions really were to create safeguards against the CMA repeatedly examining the same matters in relation to the same markets, then a rule that says the CMA can do that, but it has to head down the market study route again, we say that that's just not a sensible or effective way to achieve the purpose.
One of the things I was thinking about was the importance in regulatory context of a market study, which is why I think one needs to remember that this is a repetitively staged process. Market study, consultation, leading to a decision to make a reference, which itself is then an investigation. So in terms of legal certainty or the right to be left alone, you're dealing with a relatively low level initial investigation in the hierarchy of investigations. I'm just wondering if the policy behind the expression of principle in paragraph 50 is sound. I mean, you should only ever be subject to one market investigation. This isn't the be-all and end-all. In this context, it's the first of 3 information collecting exercises. So it's by necessity going to be relatively low level in the hierarchy. Why should you only ever be subject to one as a matter of policy from a regulatory perspective? And that's what slightly does puzzle me about this paragraph.
Yeah.
It attaches too much situation where, as here, you flag the fact that the 6-month limit that there might be circumstances in which a different decision was reached, one of which was that the government didn't pass the legislation in time.
Oh, that's right. Yeah, and in addition to the points Lord Justice Green makes, there is of course the question of outcomes, because it's not until one gets to the market investigation that the CMA has the remedial powers that arise in that context. So in terms of the burden of the process, you know, a market study can be in various places, but what the CMA doesn't have at the end of that process is the strong remedial powers that it has at the end of the market investigation. So just then to touch on, I said I'd come back to the question of the CMA taking its decision outside the market study. We say it's perfectly clear as a matter of fact and process that the reference was made 6 months after the market study. And I just want to deal with the tribunal's reasoning in relation to this, which is page 78 of the judgment, paragraph 56. And says, although the CMA's contentions treated the decision as self-standing.
Sorry, which paragraph?
I'm so sorry, paragraph 56.
Page 77.
Page 78.
77. Oh, anyway, 56.
56, yes.
56. So if the CMA's contentions treated the decision as self-standing, it is in reality no such thing. The decision is not a self-standing decision. It is an express revisiting of a matter considered and decided upon in the earlier decision, and so on. So we respectfully say that this language obscures the issue. We are not claiming that the market investigation reference was independent of the market study in the sense that it had nothing to do with it. We can't possibly say that, and we don't. It's clear that the CMA's change of view took root during the latter stages of the market study, and indeed the change of stance was explained in the final report. The point we make is that the decision, where the decision to make the reference is not made as part of a market study, the time constraints established in sections 131A and B don't apply. So it is freestanding in the sense that it wasn't made as part of a market study, and only in that sense. We say that the argument based on the natural reading of the legislation is in our favour, and that argument becomes stronger still when one looks at some of the further practical consequences of the tribunal's construction. And I'm going to deal with 3 points under this heading. The first is the tribunal's view that the test for whether the CMA can initiate a reference after the market study is over is a change in the matter. This is paragraph 51. It says that the key words are whether the proposed reference is in relation to the matter specified. These are wide words that will derive their significance from the context. And they go on and say, 3 lines down on page 76, we would go further than this. The effluxion of time in and of itself may cause the matter of a market study notice to be sufficiently different from the matter of a later reference, such that the proposed notice and subsequent reference are not in relation to the matter specified. So the idea is that if the matter evolves, the time limits under the sections 131A and B no longer bite, because the CMA has no longer issued an MSN in relation to the matter. And we do respectfully say that this is a completely vague and unsatisfactory test, which can't be how Parliament intended to draw the line between cases where the CMA can re-enter the fray and those where it can't. The test is a recipe for continued litigation so that the CMA can...
It seems to be saying, even if, as it were, today, you have reasonable grounds for suspecting that there's anti-competitive conduct, you've got to leave it for 2 years. And in 2 years' time, you might have to come back and start again, as it were.
Cross our fingers, effectively, that things have moved on so that we can conjure up some argument that this is actually no longer the same matter. And it's just that, in my respectful submission, it makes the scope of the CMA's powers depend on a sort of almost linguistic point about the definition of the matter, and not on whether there is good reason in the public interest for the CMA to want to intervene, having previously decided not to. So it moves, in my submission, the focus of the test away from where it should be to a much more technical point, which is really not serving the purposes of the legislation. I had an example on that point, but perhaps I won't take up time. I think the court has my point. So point one, the matter test is implausible and undesirable as a technique for defining the CMA's virus. The second point is that the tribunal's interpretation effectively it forces the CMA to exercise its discretion at the halfway point of a market study so as to keep its options open, even if that doesn't reflect its genuine view at that point in the process. The court's seen the CMA's position at the 6-month point in the present case, which was perfectly sound, which was that it expected to have DMU powers in relatively short order, and it proposed to deal with the issues it had identified using those powers. So that is what the CMA actually decided, which is what you'd expect it to do. Yeah. So if one can then look at what the tribunal says in paragraph 59, I think the tribunal probably just needs to read this paragraph because it's quite hard to summarise.
If the CMA decided to make an MIR at the end of 6 months to go down the reference route,
It would have been a proposal at that point.
yes, move to consultation and so on. Yeah. But on the basis, as set out in the decision, that it was doing so, as it were, to hold the ring, pending the creation of an active DMU, which would then take over new statutory powers on an ex-ante basis. On the basis of the logic in paragraph 60, would that have been subject to public law challenge, that it was not a proper exercise of the power?
Well, I mean, we do say that issue arises, my lord, because I mean the difficulty with the tribunal's reasoning is the question for the CMA at this point was, do you propose to make a reference? And
A genuine reference.
the answer to that question was no, we don't propose to make a reference. And so the tribunal is here. It's expressly saying that notwithstanding the CMA's actual belief and position at that point, it should have reverse engineered its decision.
Well, that's the whole point, isn't
To
it?
get around the
The
time
reality of
limits.
all this
Yeah.
is that what you actually did is to say we won't make a reference on the basis that legislation is coming forward. We reserve the right to change that if the legislation doesn't come forward. What they're saying you should have done is we will make a reference, but we won't, as it were, pursue it if the government passes the legislation in 6 months or 12 months' time or whatever. Which is effectively just the reverse of the same thing.
Well, it is, and that's why they say the tribunal says it's found a way out for the CMA. But the way out seems to involve the CMA taking a decision, which it doesn't really believe in, but just as a way of ducking the time limits. And we say that can't be how the scheme's supposed to work.
I'm not certain I quite understood what the cat's way out was, because it suggests one and then says, but this could be subject to public law challenge.
But I think they think this route would be okay.
Well, you start the reference procedure
Yeah.
upon the publicly known basis that you're likely to drop it if the legislation comes in.
I mean, it does come down. It's almost saying you should pretend that you're proposing to make a reference, really, even though you aren't proposing to make one. You should take that position, just to hold the door open, and then if things turn out in the way that you hope they will,
Because at the time when you make that decision, you actually believe that the government is going to pass the legislation.
yeah, the CMA didn't propose to make a reference.
Within 6 months or whatever it was. Because if the CMA hadn't believed that, they wouldn't have decided not to make a reference. They would have made one.
Yeah, so I mean, and it does, in my submission, I mean, it's not in anyone's interest for the CMA to be driven by the construction of the statutory scheme to take a decision which doesn't really reflect its position, doesn't truly reflect its position, just to keep the right to make the reference alive. That's obviously a recipe. At best, it's a recipe for confusion and wasted resources, and it can't be how the scheme's supposed to work. But worse than that, I mean, I would agree with my lord's point that if you start taking a decision that's not your real position, as a matter of positioning, then you are potentially opening yourself up to some kind of challenge. So I've already covered a third implausible consequence of the tribunal's interpretation, which is the fact that the CMA can have a second go, but it's driven down the MSN route rather than the freestanding reference. But there is the related point, which I think we've already touched on, which is how the issue of multiple MSNs and multiple examinations is regulated, and this is the public law point. The tribunal found, as we saw in 53.2, that the safeguard against abuse of the system by the issue of repeated MSNs is the application of public law principles. And we agree that public law principles create a safeguard against that kind of abuse of the scheme and the avoidance of time limits. But our point is that point applies equally to the present scenario, where the CMA has sought to initiate a market investigation without issuing a second MSN. So this really is a kind of distinction without a difference. I can take this as quickly as the court wants. The key legal principle we rely on is the Padfield principle, that the CMA must act, it must not act so as to frustrate the policy and objects of the Act. And here that would mean specifically the time limits for the conduct of a market study. Padfield is at the Authorities Bundle, Volume 1, tab 4, and I probably, it's a classic case. I probably don't need to say much about it, but I will open it. It was concerned with the refusal of a minister to appoint a committee of investigation to resolve issues which had arisen in relation to milk pricing, and the classic statement of principle is on page 158. And it runs, it's per Lord Reed, and it runs from B to D. Now, we included some commentary on this case in the bundle. We intended to, but the edition changed, and I'm afraid we put the wrong references in. So I'm just going to hand up a replacement for tab 12 of the Authorities bundle. So what one can see is that Padfield is discussed in a chapter called Abuse of Discretion. One sees that at the top of page 304. And the principle for which the case stands, per the heading, towards the bottom of 304, is judicial rejection of unfettered ministerial discretion. Discretion must be used to promote the policy and objects of the Act. And so in the interest of time, I won't go into the extract, which is between 304 to 306 of this clip. But the point we make is this: the premise for the Padfield principle is that the statutory discretion of the decision maker is engaged because the conditions for the exercise of the discretion are present. So that's the virus question. But there are nevertheless limits on the way that discretion can be exercised, having regard to the aims and purposes of the statutory scheme. And there's an illuminating case at tab 7 of the Authorities bundle.
Well, since the CAT agrees that the power is engaged, because it says that the 131 says so in terms that there were reasonable grounds and the negative conditions were not met. So we are into that word may.
That's right. That's true. That is true. But they're then saying that there's then a sort of statutory overlay.
Yeah.
So well, quite. Then the question comes back to: do those words in 131
they do.
A, related to? Do they inferentially add another restriction?
That's right, my lord. And at this point in the argument, obviously, I'm assuming
a precondition.
Yeah, and I'm assuming not at this stage in the argument.
Yes.
I'm saying the CAT's concern about the CMA effectively abusing the system really and going back over matters notwithstanding the time limits have passed and expired. We say that can be policed using these principles because the CMA can't, once its discretion is engaged, use it in such a way as to undermine the policy of the Act.
But what troubles us a bit is that how much was all this debated in front of the CAT? I mean, it wasn't part of Apple's submission, which was a pure, neat, tidy point of law. It wasn't a full-scale rationality attack to the exercise of the power.
I think it's true that the points I'm now making weren't debated with the CAT.
So
were not. And I think the reason they've come into focus is because of that finding in 53.2,
yes,
where they say, well, look, the MSN route is policed using public law principles, and I'm really unpacking what that means. And I'm
you're just
demonstrating, I
saying
hope,
if the preconditions for the exercise of the power are met and the power is engaged, it's not an unfettered power, it's subject to a classic Padfield proper purpose.
that's exactly, my lord. But what I'm saying is the CAT envisaged that the points I'm making, implicitly would be safeguards in the second MSN scenario.
Yeah.
And I'm saying, well, that's right.
Right.
And they're also safeguards in the scenario that you're actually dealing with. So one doesn't need to stretch the time limits to create a safeguard. The safeguard is there.
Safeguards exist in any event.
Yes. That's the point. Yeah.
Did you want us to look at Ben Hall Bell?
Yeah. Look, I won't spend time on this. I just wanted to. I can probably just show you one paragraph, which is paragraph 17. And if the court wants to look further at it, obviously it can do so. Paragraph 17. This is Lord Justice Beatson, which it's tab 7 of the authorities volume 1. And this is a challenge to regulations which had limited the availability of legal aid for judicial review to particular circumstances, and there were various forms of virus argument. And what paragraph 17 does is it distinguishes between two alternative grounds, that is to say, ultra vires and incompatibility with statutory purpose, i.e. a ground based on Padfield. And interestingly, the paragraph then draws the distinction between strict ultra vires and Padfield, which is a form of ultra vires. And the court may or may not find that taxonomy helpful. In my submission, that's really what we're dealing with here. The CMA has strict vires, and there is a safeguard in the application of the Padfield principle to ensure that it acts compatibly with the purposes and objects of the statutory scheme. And I probably don't need to spend more time on that case. I personally found that an illuminating way of expressing the principles. So we say that a decision maker may have strict vires to act, but that doesn't prevent a searching examination of whether the decision maker has acted compatibly with the scheme and purposes of the legislation. That's the basis on which the tribunal envisages that the second MSN scenario will be regulated and controlled to the application of public law principles. We anticipate that the tribunal means the sorts of principles we've just been looking at, and we simply say that if the Padfield principle is effective to prevent abuses of the statutory scheme in the scenario contemplated in 53.2, it must also be effective to regulate the present scenario. And this also removes the oddity of the tribunal's construction, under which the CMA is in principle able to initiate a second process under one route, but not by another route. We say that's an inconsistency within the tribunal's interpretation, and it's an unnecessary inconsistency. So that's ground 1 of our appeal. I can probably address ground 2 very briefly in the light of everything I've already said. Paragraph 55 of the judgment, I think that the court's already seen it, at CB 77, is where the tribunal addresses this question of material change of circumstance. I think the court has my point about this. The tribunal says that it isn't dealing with material change of circumstance and other related issues which may give rise to reason for the CMA to want to
I
reinitiate.
suppose, as we've discussed, those issues weren't in front of it. There was no rationality challenge. So it was a pure question of jurisdiction.
Well, I think that's right, but I think, my lord, the issues arise in the context of how to make sense of the statutory scheme. And I think the CMA's point was, look, we have a case where there were material changes of circumstance. We say there are obviously good reasons in the public interest why we should be able to act in this situation. And a construction of the Act which prevents us from doing so, which creates an absolute bar in terms of vires and prevents us from doing so in that way, that undermines the statutory purpose. So the issue arises in that way, albeit I would accept indirectly. And the point we make about 55.1 is that although the tribunal purports to hold a sort of material change of circumstance argument open in this paragraph, the effect of the judgment is really to close off that sort of argument, as the present case shows.
Yeah, but that's the point that my lords have already articulated. There's an illogicality because either it's an absolute bar or it's not an absolute bar.
Yeah.
You can't say it's an absolute bar, but there may be a get out due to change of circumstance.
Yeah, well, I accept that, my lord. But the effect of the judgment is clearly, whether the tribunal recognised this or not, to close off the scope for the CMA to change its mind where circumstances change to a very significant degree, and that's really the point we take from that. And as I've already explained, our construction doesn't encounter that difficulty. It resolves the tension by construing section 131 on the one hand and then applying the overlay of the public law constraints on the other one. And we do say that, and perhaps I'm going beyond the limits of the argument now, but we do say that clearly by acting in the way that it did, by reacting to changes of circumstance, including delays to the passage of expected legislation, the CMA clearly didn't undermine the statutory time limits. It took a decision which it couldn't have taken, wouldn't have taken at the earlier point in time because the circumstances didn't then pertain. And we say that changing your mind when the facts change is not acting so as to undermine the statutory scheme.
I mean, there can always be some changes of circumstances which are not relevant to the exercise of a power. But the two identified are, one, the efficacy of using a particular regulatory tool. The second is the fact that you've got 48 new sets of submissions. So it seems to be a suggestion that neither of those are proper changes of position. But it seems, well, on one view, that one relates to the efficacy of the regime to regulate an issue that's confronting you. And the second is the quality and volume of the evidence relating to the concern. They seem fairly mainstream regulatory considerations.
They do, my lord, and they're also connected, of course, because when we looked at the final report, paragraph 914, we saw that some of the representations were specifically calls for action now. So they weren't just saying there's a problem; they were basically saying we can't wait for the new regime. You need to act now, and so in that sense, the two things tie together. I mean, perhaps I don't need to take up time on it, but you've seen from our skeleton argument we take strong exception to paragraph 60 of the judgment, where the tribunal goes so far as to say that the CMA erred in law by exercising its discretion with reference to the anticipated availability of new powers, because it says that was an immaterial consideration. And I don't believe that Mr. Otti defends this paragraph. That might be because it's obiter, it might be because it's not, in my submission, defensible. But with respect, the observation is clearly wrong, both on first principles and as a matter of authority. On first principles, it is obviously not unlawful or irrational for a decision maker in the public interest to have regard to anticipated changes in its powers when deciding how to act and how to allocate public resources. That is exactly the sort of matter that
That's a key question on this, isn't it? I mean, instinctively, because I put it in terms of the efficacy of the tools available to the
Yes.
regulator. But that's a key question. Is that a relevant consideration to be taken into account? And how do you determine that? Well, you ask yourself, I suppose, how close is it to the core of that decision maker's powers? It goes to the efficacy. What's the most efficient way? You move from an ex ante to an ex post to an ex ante regime. And of course, we know that by this time they'd at least adopted the regulation in Europe, although it hadn't yet become effective. They're still in the transitional period.
Yeah.
And the government and the CMA didn't want to be left behind. So, I mean, it was plainly on everybody's radar. Difficult to say it's out with the scope of relevant considerations.
Yes, and I would strongly endorse what my lord says, but there is the further point, which is the obvious contextual point, which if one looks at the history of this process, in circumstances where it's perfectly clear that a central theme of the market study had been the anticipated use of these new powers, and with the CMA gearing up to hit the ground running and all the rest of it, and the decision at half time being a decision not to make a reference, notwithstanding that the threshold's met, because the DMU would be better placed to use the language of the report to take those steps. We say all of that has to come into the mix. So we say on first principles those things are obviously relevant considerations. We've also included Court of Appeal Authority on this point in the bundle. I don't know if the court wants to see that. This is my last point actually, so maybe I will show the court it briefly. This is a Birmingham case, which is Authorities Bundle tab 5.
Yeah.
So the context for this case is that there had been a legal issue as to which types of fund should be taken into account when the Secretary of State prepares what's called a rate support grant report. And if you look at page 192, there's a paragraph when the system was first introduced, and that explains the issue. The prevailing understanding had been that a particular view referred to as the narrow view is correct. The narrow view turns out to be wrong, and so there's a plan to bring in new legislation. That's the context. So it's not like our.
Where are we looking at?
I'm so sorry. Page 192.
Yes.
When the system was first introduced, it's the first main paragraph, top of the page. That just explains the issue.
Yes.
So just to begin, this is not a situation of alternative toolkits, to use my lord's language, but it is a question about whether a decision maker can properly take into account anticipated changes to the legislative environment when taking a decision. And if you turn over to 194, and if you read, if you see in the middle of the page, Mr. Henderson's second submission, if you could read that paragraph and the next two paragraphs.
Yes, this is interesting because as here it contemplates a change of circumstances outside of the present legislative regime, which might be the point perhaps taken against you as to whether it's a relevant consideration. Does it have to be within the same regime?
When my lord gets to the end, I take a more general point from this towards the end.
Right.
Towards the end of the paragraph, which refers to Willow Wren. So
That's just, yeah.
yeah. So
That's sort of dealing with sort of paragraph 53 2 points as well. It's dealing with point. The suggestion from the CAT was that you could have a new market study notice. It was the only way in which you could proceed is to have a new market study notice and start the whole procedure all over again.
Yeah.
Complete waste of time and money. If you've reached the point where you now say, well, a market investigation reference is necessary.
yes, we do say that, Lord, yes. And look, I mean, obviously, on the facts of that case, the argument is dismissed in extremely strong terms. I don't need to go quite as far as some of the language of this judgment, contrary to the plainest common sense and so on. But the key point is the point at the end of that Willow Wren paragraph, which says the court must enforce the law as it stands. It has no choice. The Secretary of State had a choice. He had to decide what to do. To say he had to disregard the possibility of, in that case, seeking a change in the law would, as I've said, been observed. So we're not dealing with it. We're not seeking a change in the law, but we're expecting one to come through.
It's the difference between a judicial discretion, which is simply to apply the law as it is,
Exactly.
and an administrative or a political discretion, which is broader. Question is, CMA is not the Secretary of State, who in a sense has maybe a broader discretion. CMA has a discretion under an Act. So the question is whether it can take into account something which is not in the Act,
Yes.
even if it's on one view common sense.
Yes. Exactly. And we say
You
this
say
is public law rationality, of course. So I mean, there's no legal impediment to the CMA taking it into account. But this is the tribunal takes the view, I think, that this is unlawful. But it seems to be unlawful because it's an irrelevant consideration. But that is absent statutory prescription. That's policed according to a rationality test. This ultimately comes back to rationality. So we do respectfully say that paragraph 60 is plainly wrong. It was lawful for the CMA to take into account both expected changes in its legislative powers and then subsequent delays to those powers, and we say that there is no basis on which to impugn the decision to make a reference.
This would be relevant had the challenge been to the earlier decision, but the present decision is not premised upon legislation coming into effect. It is premised upon the fact that it needs to use its powers now.
Yes, that's right.
So in a sense it's the converse of this.
It is the converse part. So unless I can assist the court further, those are my submissions.
My Lord, of course we say the appeal should be dismissed for the reasons given by the tribunal in its judgment and in its decision refusing permission to appeal. I'll summarise our position on each of grounds 1 and 2 in a moment. I'd like to make 2 preliminary points at the outset, if I may, just to emphasise them. Firstly, our challenge is and has always been a vires challenge based upon the correct interpretation of the Act. It has never been a rationality challenge and it has never been a legitimate expectation challenge. Secondly, to preview a submission I'll come to and to answer directly one of the questions posed by my Lord Justice Green, the statutory purpose of the provisions we rely upon and the time limits which we say they impose embraced speed of decision making on the part of the regulator, certainty of outcome for all persons affected, and proper balance between the conferral of extreme investigative powers without any evidential threshold whatever being crossed, and the need for protection of those subject to those powers. And we see that, we say, that statutory purpose running through the scheme of the Act as a whole, and we see it underlined in very clear terms by the secondary materials that the court is entitled to have regard to in the form of both explanatory notes and pre-legislation consultation documents. So with that introduction, my lords, we say ground 1 fails for 4 reasons. Firstly, the natural meaning and effect of sections 131A and B of the Act, read in the context of Part 4 of the Act as a whole, is just as the tribunal held. It is that where the CMA has published a market study notice, the mandatory time limits laid down by Parliament occupy the field. And the CMA is, for present purposes, required to do 2 things. 1, to publish any proposal, that would be an MIR, in relation to the subject matter of that notice within 6 months. And secondly, to take any decision that there should be a reference in relation to the subject matter of that notice within 12 months. And in the present case, as the agreed chronology shows, the CMA failed to meet either time limit. Now that is the interpretation set out by the tribunal at 41 to 44 of the judgment, and summarised by us at paragraphs 4 and 10 to 17 of our skeleton argument. And that's the first reason ground one fails, we say. Secondly, related to one of my preliminary points, that interpretation is consistent with the legislative purposes of expedition, certainty and balance, reflected both in the legislative scheme itself and in the admissible secondary materials. Thirdly, and in contrast, we say, the effect of the CMA's interpretation would instead be to largely deprive those time limits of any effect, to render the decision not to make a reference taken and published in December 2021 nothing more than a provisional view, no different analytically and in substance from a proposal, a quite distinct concept. And it would frustrate the statutory purposes I've just referred to. These are the matters we address in our skeleton argument at 23 to 26, and by the tribunal at 34 and 56 to 60. And the effect of the CMA's interpretation would be to allow it the benefit of very extensive, unusual powers, backed by penal sanction, without assuming any material burden. And the fourth reason ground one fails, we say, my lords, is that the CMA's core case in seeking to avoid the time limits that you've heard explained this morning and that it's set out in paragraphs 51 and 60 of the CMA's skeleton, that the limits did not apply because its June 22 proposal for an MIR was entirely separate from and outside the market study process, is, we say, artificial and ill-founded in fact, but for good measure, and perhaps more importantly, it depends on a straightforward rewriting of the relevant statutory test for when the time limits apply. And that's all set out in our skeleton at 36 to 40, my lords. And that's, in summary, why we say ground one fails. As to ground two, and the argument that the tribunal should have held that the CMA was entitled, as a matter of discretion, to act as it did, given the changed circumstances, that case fails for two reasons. Firstly, if the CMA is wrong on the issue of vares, then any arguments as to the breadth of its discretion, such as those advanced by ground two, fall away.
That's accepted. Mr. Williams accepted that he, if he lost on ground one, ground two didn't arise.
I'm grateful, my lord. I won't take any further time on it. That's in fact, I don't even need to go to my second point. That's a complete answer to ground two. So it's ground one that matters. And I'd like, if I may, to go through each of those four areas: legislative framework, true statutory purposes, consequences of CMA's interpretation, and rewriting of the statutory test. Now, legislative framework, first, my lords. The core principles of interpretation are not, of course, controversial, and they weren't controversial before the CAT. There are authorities in the form of the O decision in the Supreme Court and Benyon in the bundle. I don't need to go to them, but I'd just like to emphasise, if I may, what we submit to be the three key interpretive principles which inform the correct analysis of the issues on this appeal. The first, of course, is that the primary source in identifying legislative intent is the legislative text itself, read in the context of the remainder of the relevant part of the Act. So not just section 131A and B, but the full run of sections in Part 4, and indeed earlier in the Act, to the extent they inform. Secondly, external aids to interpretation, particularly explanatory notes, may play a secondary role in casting light on the meaning of particular provisions and in facilitating a properly purposive interpretation. And thirdly, the principle of effectiveness means that an Act must be construed so that its provisions are given force and effect consistent with the identified statutory purpose, rather than being rendered capable of evasion or bringing about a pointless result. Turning then, my lords, to the legislation itself. It's in the authorities bundle at tab 1. Before going into the wording of particular provisions themselves, and again by way, I suppose, of preview, but just to emphasise 3 overarching points that I'll be returning to throughout the scheme of the legislation and indeed throughout consideration of the secondary materials are these. Firstly, the overall scheme of the legislator was to provide for 2 different regimes, 2 different scenarios. One where a market study notice had been published, and another where no such notice had been published. Secondly, a core purpose of the legislator, common in fact to both regimes, was to promote expedition in decision-making by the regulator. And as part of that, we say, to provide hard-edged outer time limits, not targets, not indications of good practice, hard-edged outer time limits within which key decisions had to be taken, with mandatory words used throughout, shall, not may language in the material provisions, and with provision for the reduction by the Secretary of State of the relevant time limits, but not their extension. And the third point is that to allow, we say, the CMA to comply with those strict time limits, Parliament at the same time gave the CMA the very intrusive and extensive investigative powers I've referred to, backed by penal sanctions, section 174, from the moment it published a market study notice or from the moment it made a market investigation reference. And the significant difference being, as the court's already noted, that you do, and as I've already emphasised, you don't need to clear any evidential threshold at all to clothe yourself with the investigative powers that flow from publication of a market study notice.
Why did you say the powers are intrusive? In the sense that are they any greater than you find in other regulatory regimes? And they're always, in all regulatory regimes, backed by penal sanctions for non-compliance.
Well,
But I understand
yes.
They're burdensome, undoubtedly.
Yeah, my lord, I didn't say unusual, unprecedented. I said intrusive. They allow the CMA, my lord's very familiar with them. We'll go to 174. They allow compulsion of the attendance of witnesses.
They're mandatory and they're intrusive.
Yes, and we see they're recognised and characterised as such in the explanatory notes.
Yes.
And they're given to the CMA because Parliament recognises that it's imposing time limits on the CMA.
Yes.
But that means that it's going to have to give the CMA the tools to comply with those time limits.
Understood.
So, yeah, that's what it comes to. Well, I'm about to go to section 5 of the Act. I don't know whether that's a convenient
No,
moment.
there probably is a convenient moment. We're all right for time, aren't we, Mr. Arnold?
We're all right for time, my lord, and I hope that's a helpful preview of where I'm going. I'll be going into the legislation in more detail after lunch.
Thank you very much. 2 o'clock, please.